for showing up. I appreciate each and every one of you. My name is Anibal Suriel, and I am the managing partner at Solidity Law. We're a Miami-based law firm, and today we are talking about the pillars needed for your project's legal foundations. The reason I wanted to talk about this topic specifically was more so, having a talk geared towards you guys as developers. I know it's not the first thing on your mind when you're thinking about what do I need for my project. You're more so there to, bring your product to life and whatnot. And this I understand very much. So I did want to bring a little bit of a value piece for you guys. Towards the end of the presentation, there will be a QR code where you can go ahead and download a free checklist for any sort of legal forms needed for the different pillars, right? So with that, let's move on. And just before I begin, I guess a little bit about myself. I'm a self-styled blockchain attorney, but that's a bit of a catch-all term. It really means an attorney who practices in multiple different fields, right? So one day I may help you guys incorporate your company. Another day I may help you guys register your trademarks, your copyrights, maybe draft some employment contracts, and depending on what your project is doing, more particularly in regard to tokens, I can help you guys either shape the product so that it avoids SEC scrutiny, or I can help shape the product so that we can actually register it properly with the SEC. That way you guys have no worries as to what's going to happen down the road. So with that being said, the 6 pillars that I do want to talk about are the corporate structure and the internal operations for your company, intellectual property, your hiring practices, data privacies and the terms you have with third parties, anything when it comes to fundraising and financing, and then of course the more important things for you guys, the blockchain, digital assets, and Web3 aspects to your projects, right? So with that being said, I did tailor the presentation so that it speaks a little more to you guys, right? I originally had put together something that just covered the basic contracts that you might need, but I wanted it to be a little more engaging. And with this sort of intimate crowd, if any of you guys have questions just off the bat, feel free to jump in and ask, right? So with that being said, a lot of the times you'll see the news and it's something new that's coming out about, for example, with regards to the corporate structure and the latest thing, DAOs. I think a lot of people here are aware of how OkiDAO was recently sued by the CFTC, and this was because they were in violation of a lot of CFTC laws, right? They were operating a commodities exchange, et cetera, et cetera. And the important thing to highlight there is that I know a lot of projects here in the space are on the latest things, right? DAOs are a trend. I ask you guys to maybe take a step back and think about, do we really need a DAO? And if we're gonna do a DAO, let's do it correctly, right? Because what happened in that situation with OkiDAO is that the CFTC went ahead and sued OkiDAO as an unincorporated association. What does that mean? That means everybody who's a part of that unincorporated association is held severally and jointly liable for anything that the DAO does. And this isn't the best news for you guys, because you want to avoid that sort of liability when it comes to maybe a rogue actor doing something illegal through that DAO. Because each and every one of you as a token holder, depending on the governance token and depending on the underlying agreement beneath that token, you may be held liable for that DAO's actions as well, which is, of course, something you want to avoid. So, of course, when it comes to thinking about, okay, what do I need to do here? Make sure to incorporate if you can, think about what you need, have the right agreements in place with the founders and other shareholders. That way there's never any sort of situation as to, creating bottlenecks for your company, or maybe who is going to be held liable in this sort of situation. It's always better to have the clarity before, moving forward, right? So that's pillar number 1. Pillar number 2 is the intellectual property. And this is arguably one of the more important pillars because it affects the other ones, right? If you don't have your intellectual property rights under lock, it affects the value of what you can bring when you want to go ahead and fundraise, right? One of the more important things that too many people do not know about are, keeping a track of your IP portfolio. What goes into this is, listing out everything that you have when it comes to trademarks, copyrights, intangible assets, things like that. That way, when you go to fundraise, you have a document that pretty much shows, hey, look, this is everything that we own, and this is why the company should be worth X, Y, Z, right? So this is something to look into. And other than that, some of the tools that you can have in place are, making sure that you are getting the IP from your employees and independent contractors, making sure that you're registering your trademarks appropriately. That way, if you do have to go to court to defend it, you're ready to do so. So that's pillar number 2. Pillar number 3 is more about hiring and how you go about engaging other people, right? So, of course, we're in the crypto industry and everything is very global, and the sort of ethos in the space is very much that because we're global, we're not really subject to any one jurisdiction, but this couldn't be further from the truth, right? Every country has the right to enforce their own laws, and the reality of the situation is that when you have employees in another country, you will be subject to those laws, and that maybe you're not providing the right benefits for these people, maybe you classified an independent contractor incorrectly as an employee or vice versa. These are sort of things you want to avoid because fines can run anywhere from the thousands to the tens of thousands and scaling up and up and up. What I would recommend, because this is such a global industry, is look into something called employers of records. This is something like remote.com or deal.com, where pretty much these companies have companies set up in each and every country. That way, if you find a developer out in Poland, you don't have to worry about the admin fees. You don't have to worry about the legal headaches. You don't have to worry about all these other things that, frankly, would be way too expensive for you to go out and incorporate a company out there, right? So these companies go ahead and take care of all of the headaches for you, and your employee would essentially be delivering the services exclusively to you. That way you're legally compliant and you never have to worry about like, oh, maybe the labor department's gonna come after me, maybe they're not, we'll see. But that being said, the next pillar is data privacy and terms. What I mean by terms is more so the terms that you have with third parties. So if you were to have a website, this can look like the terms and conditions. If you were to have an app, maybe it could look like a EULA, things like that. And if you're a B2B company, then you should for sure have these sort of professional services agreements in place. These things are important just because, for example, Celsius, the situation with Celsius came into the news because their terms and conditions allowed for them to keep onto a lot of people's funds at the end of the day, which to a lot of people wasn't the right thing, but the judge did what the judge was supposed to do. They read the law and they just said it, they read the case for what it was, right? All of this to say that when you bring these things in place, it's important for you not to just copy and paste from another website, not to just go to ChatGPT and say, hey, type me up a terms and conditions. The issues there is that everybody's projects, especially in this space, is highly personalized. There's things that you may not think about that are missing. There's things that you may add to the terms and conditions. And what ends up happening is, for example, if you have a disgruntled customer, they go ahead and make a complaint to the FTC. The FTC will go ahead and say, okay, we're going to look at your terms and conditions and your privacy policies. And if you're doing something that's not in there, the FTC can very much say that you guys are doing unfair and deceptive practices. And that is very much, that comes with its own fines, right? So it's very important to, pay attention to these things. And it's not a trivial thing to just go out there and try to be your own lawyer. At the end of the day, if you're trying to be your own lawyer, you can't go after somebody when something goes wrong, is one thing I want to say. And then with regards to data privacy, it really is developing a field, at least here in the US, it's a bit of a patchwork when it comes to, California has its own data privacy protection laws, Virginia as well, et cetera, et cetera. It is important to go ahead and have, somebody there to guide you and say, hey, look, let's have a normal terms and a normal privacy policy. Let's have a separate privacy policy for those in California. At the end of the day, you can never really control with who is going into your website, who's buying your products, et cetera, et cetera. So it is better to be prepared versus not be prepared, right? And then one of the other pillars, right, is financing and fundraising. In these sort of situations, I highly advocate that you make sure you have the right agreements in place, because I've personally witnessed situations where I'll have a friend who builds a company with some other individuals. Those other individuals never put in the work that they say they would put in. Now all of a sudden they have all of these shares without putting in more effort, or they go ahead and try to strong arm the situation and dilute the other individual shares. Something that you want to avoid. You don't want to end up like Facebook and the Winklevoss twins and everything like that. Very much, this is an area that you should pay attention to, right? And when it comes to financing, of course, in crypto, there's a lot of talk of, let's do an ICO, no big deal. But the situation here really is that the SEC views 90% of tokens out there as securities. Whether you agree with that or not, it has really no bearing, because Gensler will go after you. Whether it's 2 or 3 years down the line, they will. So I'm a huge advocate of either trying to shape your token, maybe like one that's called Pocket Full of Quarters. I would look that one up. That one is very much not a security. They got a no action letter from the SEC. Or you can always go ahead and register it with the SEC or do an exempt offering. And it sounds complicated, but at the end of the day, it's not. It really is about just providing a pitch deck, providing all of your promotional materials, and letting the public know, hey, look, this is what's going into the project. These are all the risks, and that's pretty much what the SEC cares about. Right now, they're really only going after the worst of the bad actors out there. They're going after the very high-profile, blatant actors. Maybe you can slide by for 2 or 3 years, but it's always better to assume, hey, look, I'm more than likely issuing a security, and worst case scenario, you can go to a lawyer to get a token legal opinion to go ahead and say, hey, look, as of right now, with the promotional materials and how you guys are doing your business, this is more than likely a security or it's not. And that can be your sort of insurance to a certain extent, right? Yeah. So it's not really, I don't believe it's a ruling. It's more so that the SEC is going after them because they're alleging that the NBA Top Shots are securities. And what are they? They're just NFTs. Maybe a security. What really goes into that is everything is based off, and I'm sure you all have heard it, the Howey test. And it's pretty much, if something is an investment contract, it's a security. What is an investment contract? There's about 4 prongs to that test. And it's if you're pretty much bringing together investors' money in a pool with the expectation of profits based off of the efforts of other individuals. So when I say a token legal opinion will save you for a fraction of the time, it's because it really does depend on the way you're marketing something, right? If you're marketing something as, say, hey, look, come buy this token because it's a great investment, you're selling pretty much the opportunity of, hey, let's make money by you buying into this. That, the SEC would say, that's a security because you're selling the investment opportunity there. And if I were to go ahead and assume why the SEC was going after Dapper Labs, it's because they very much marketed it as a way of like, hey, come buy these NFTs, we're the first in the space, you're gonna make money, et cetera, and that's the issue. So maybe at the end of the day, you're not selling stock from a company, which is a security, right? But if you're selling something as an investment opportunity, that's what the SEC is going after. It's the way you're marketing it. You could always start off with a security and then can end up not being a security, and vice versa. So it's always important to pay attention to the way that you're marketing something or the way a company is marketing something, pretty much. Does that answer your question? Yeah. In my view, no, no. But the issue is that you have to go by the way maybe Gensler would. Unfortunately, there hasn't been much actual precedent set other than like library token. What else? Right now, Ripple is still going through. That one would have a huge impact in setting actual precedent. But a lot of the times, things go to litigation, they end up settling, and then there's no precedent off of that, right? But yeah, it's always best to consult with an attorney, and they'll tell you, hey, look, even if it's just a white paper that you have, somebody will take a look at that white paper and say, hey, look, you should change X, Y, and Z just to avoid unnecessary problems, right? Yeah.
Thank you. You mentioned one specific term for the non-security token. You said something like in the middle of your of that previous slide that I didn't get the term that you used, but was really curious.
What was the term?
When you were saying how the 99% of tokens are considered as securities, and you said kind of position your token
there was a certain
as
case out there, yeah. So there's a case called Pocket Full of Quarters or Pocket of Quarters. Pocket Full of Quarters, I think is what it's called. This case, it was pretty much a dad and a son that got together. They created a token, and it wasn't a security because it never left the system. There was no sort of advertising to the token itself. There was an unlimited supply. There were just a lot of things that lended to the fact that it wasn't meant to fundraise. Literally, it was just meant as a way of transactioning on the platform, and that's it. The SEC is not interested in going after projects like that. If it's a closed loop system, if it's more so working like a gift card, you shouldn't have issues there. But when your main goal is to say, hey, look, come buy this because there's an investment opportunity here, that's when you're going to run into problems. And this isn't to say, like, be afraid of that, but if that's what you're going for, do it correctly. There's a whole bunch of exemptions out there that you don't have to do full registration with the SEC. There's Regulation CF if you want to raise anything below 5 million, I believe. There's Regulation A for anything below 20 million, and then Tier 2 for anything below 75 million. And these are really, they're not easy to do, but they're a lot easier than full-on registration with the SEC. And it'll take 3 or 4 months to do these sort of exemptions, but I would think that's better than dealing with the SEC in 2 or 3 years.
Strictly speaking, I can imagine many projects can, right now, altcoins, right? They can qualify for this pocket full of quarters definition, right? Because those tokens are used to transact in the ecosystem. And yet, obviously, all the cryptocurrency investors, they do expect appreciation, and that's the reason why they invest. But what will prevent the SEC from calling them as securities if it's, it can be like a DOT token, or maybe DOT is actually a bad example because they were called the infrastructure token, something like that, right?
Yeah.
But for example, Phantom token, for instance, right? It's used in the Phantom ecosystem across many Phantom chains. So why would we think that SEC will still apply the definition of the securities to those tokens? And I understand it's a completely vague area to everyone.
Yeah, so because I'm a lawyer, I'm always going to say you should err on the side of caution, right? There's usually 3 approaches that I recommend to a client when they speak to me first. They tell me what their project is, and I say, look, you have 3 options here. You can either try to tailor it so that it's not a security and just go to market. Hopefully, the SEC won't pay attention to you. You can get a legal opinion done. That way, you have some sort of paper that says, hey, look, I never went to market with a security. The third option there, and actually there's 4 options. The third option there is to get that token legal opinion and then to sort of interact with the SEC and say, hey, look, I'm looking for a no action letter take a look at my token. These are the features. Can you let me know whether this is a security or not? If they issue it to you, amazing. I know the SEC nowadays is very understaffed. And then the fourth option is to either go for an exemption or to do the full-on registration. The reason I recommend the exemptions and the full-on registration is so that you can go ahead and market your token the way you want without ever, worrying about, is the SEC going to come after me? But those really are the four options. So let me ask you, is there an issue with it being a security?
Understanding is we would rather have a wider holder base for the token because those, like if it's a registered security, then only qualified investors can interact with it, correct?
Yeah.
That's the drawback. Then I can imagine for most of the crypto protocols, the preference will be to not be considered a security. So then the full registration is like the last,
well, I mean,
the most complex.
It is the
decision.
most complex, and I would say 90% of the cases, you don't need to do full registration. This is why I advocate for the exemptions. So Regulation CF, Regulation A, Regulation D, Regulation S, it's a whole bunch of terms that kind of like gatekeep. I get that, but my point is the rules are very clear and it's not hard to do these exemptions.
Okay.
Yeah.
So crypto lawyers will be able to advise obviously on the application of the exemptions.
Yeah.
Beautiful. Thank you so much.
You're welcome. Go ahead.
That a closed loop token won't be a security. So in that case, what happens if a trading market develops on its own later on? So for example, we issued these closed loop tokens, and after that some time people start using that, trading that. What happens at that point of time?
So so when I first mentioned the 4 prongs of the Howey test, there is a lot of case law that goes into it, right? If you as the company are sort of actively building that secondary market, you're saying, hey, look, we put together this platform, you could trade it, the SEC would look at that and say, okay, you're supporting a secondary market, and that goes towards the 3rd prong and saying that the profits are based off of somebody else's efforts. But if you're telling me that a secondary market develops on its own, that is totally fine. If it organically develops on its own, it has nothing to do with the efforts that you put in as a company, you should be in the clear, pending the other factors, right? Yeah. Any other questions? No? I'll continue with the other pillars. Well, okay, so the last pillar that I wanted to talk about, because it's such a niche industry and developing laws in the US itself and outside, you really should have in place very tailored documents, right? So if you were to go for maybe an ICO, I would look at maybe putting in place a simple agreement for future tokens, you having a token user agreement, that way no one can go ahead and use the NFTs against your own wishes, maybe sort of you want to reserve certain rights for yourself, et cetera, et cetera. These sort of agreements that I have in place there. And don't worry, actually, the next slide, I have a QR code if you guys want to scan it, just to make sure you have all the documents in place. More than welcome to. But yeah, I mean, that was pretty much my presentation. If you guys have any sort of questions, I'm a very approachable person. Feel free to ask anything. And let me pull up the QR code. Cool. So, only other thing I could say is, yeah, if you have any questions, just please approach. At the end of the day, I try to, yeah, that's it, guys.
Give
If
him
you
a
have
round
any
of applause,
questions-
guys.
Thank you, guys.